Ready to go? The Rules Committee will come to order. I was always taught that if you say something really nice about somebody and they're not in the room, that it means that you really mean it. And so I want to congratulate Jared Polis, who just became a father on Friday with the birth of Caspian Julius. And so it means that we really mean it. Let's give a round of applause to Jared and Caspian Julius. Thank you all very much and welcome back. I hope everyone, including Mr. McDermott, had a good week. And I've just spent the last week with Mr. McDermott, and we're happy to welcome him. Let me say to our colleagues that we are here for the... Kevin Brady, climb aboard. We're happy to have you. We are here for consideration of two measures, H.R. 2832, and, well, three measures. We'll have two rules for consideration of them. H.R. 2832, H.R. 2250, and H.R. 2681. Before we proceed, let me first recognize for an introduction our friend from Dallas, Mr. Sessions.
Mr. Chairman, thank you very much. Mr. Chairman, I'd like to introduce a young woman who is from Southwestern University, a student intern in our office, Gabrielle Eggleston. Gabrielle is a senior at Southwestern University, of which I'm an alumnus and which Kevin Brady is always nice to because he knows Southwestern in Georgetown, Texas. And Gabrielle is up here on an internship, and as we spoke today, she told me she's very impressed but disappointed that she had not yet attended a Rules Committee hearing. So we're
happy to have you, Gabrielle. We know you won't be disappointed.
Today.
We know you won't be disappointed. Thank you very much for being here, Gabrielle, and good luck to you. You're about to see this great process in action. Okay, we'll join Mrs. Slaughter. Okay, Gabrielle. Now I'd like to represent the distinguished ranking member of the Committee on Rules, Mrs. Slaughter.
Thank you, Mr. Dreyer. I would like to make an opening statement, if I may, about the jobs bill. As we all know, the President has put forth this jobs bill that he's asked us to consider it immediately. We see no indication that that's going to happen. But the provisions within the American Jobs Act have all had bipartisan support in the past, and we would hope that they will in the future. But while we wait that action, there's something that only Rules Committee can do, and we'd like to bring that up to you today. We are sending you a letter today requesting some immediate action on the three job creation bills by Mr. Larson of Connecticut, referred to the Rules Committee, and let me present you with that letter.
I was going to go and sit by the mailbox. I guess I don't have to.
No, the post office would deliver it, I'm sure, but we'd be happy to do that. Each one of them, I think, has a pretty common sense approach in different actions on jobs. And the fact that this Congress has taken absolutely no action on presenting any new job creation to the United States and spent more time, I think, on light bulbs than we have the unemployed, we would really like it if we could consider those and act upon those right away. And we appreciate it very much. We've run out of ways, I think, to say that we think it's high time. But we have an opportunity as a committee to do that today.
Well, thank you very much. Thank you very much,
You're very welcome.
Mrs. Slaughter. And let me express my appreciation for the letter. I'm going to read it carefully. I'm familiar with the legislation, and I totally concur with you, as I know all of my colleagues do here, on the need for us to focus on job creation and economic growth. We all sat and listened patiently and to the President's address to the joint session of Congress, and he talked about a number of provisions in that address to us. One of them is what we're going to be addressing at this moment for his quest for job creation and economic growth. It was one of the key parts of his address to us. Yeah, trade adjustment assistance and, of course, the three agreements, which he said he wanted us to pass.
Well, I really want to point out, too, that the economists have gone over this with a fine-tooth comb. The consensus is that this will really create some jobs, and we really should be getting at it because it will take time just to get it past both houses, signed and implemented.
Right.
So we'd like to move on that.
And as I said, you know, obviously we're going to be taking a step. I hope it's all finalized next week for something that will be opening up new markets around the world for U.S. goods and services, which are really critical. TAA
is fine, but as we all know, that's for people who've already lost their jobs. And frankly, if there were a lot of jobs out there for them, we probably wouldn't need TAA. I don't find that much of a... I disagree with the administration that that's going to have any great effect here. But the jobs bill itself, I think, will.
So you disagree with part of the request that the President's made?
It's just a personal thing for me to say that TAA is going to answer the problems here. Well,
I think that what the President was arguing is that the answer is for us to open up new markets around the world, which is exactly what we're going to be doing just before we, I hope, pass the TAA bill itself. So
Yeah.
let's proceed and again,
Well,
get
I'd
to
love
job
to see
creation.
one of those that
I
benefited
agree.
America.
Yep.
All right, thank you
Thank you very much,
for your time.
Mrs. Slaughter. I appreciate it. We're very happy to welcome the leadership of the Trade Subcommittee of the Ways and Means Committee, my good friends Kevin Brady and Jim McDermott. And I thank both of you. I've had the privilege of working with both of you over the years on the issue of prying open new markets around the world for U.S. workers to have access to those markets with goods and services. And so we welcome your testimony. And let me just say that without objection, you both look like you have brilliantly prepared statements there. And I will say that without objection, they're both going to be submitted to the record. And if you'd like to offer a summary to us, that would be terrific. So, Chairman Brady.
Mr. Chairman, members of the Rules Committee, thank you. I will submit this to the record and simply say that today is a historic day. After 5 years of being off the trade field, America is stepping back onto it. Congress has the opportunity to move a preference and trade adjustment assistance bill critical to that agenda, one that helps create jobs here in America for farmers, manufacturers, technology and service companies. The trade adjustment assistance provision is a bipartisan compromise that streamlines the program, reduces its cost, is fully paid for with spending cuts, and gives us an opportunity to work together on both helping those impacted by trade as well as finding new jobs by selling American products throughout the world. With that, I strongly support this measure and am here to answer any questions.
Thank you very much, Mr. Brady. Ms. McDermott.
Well, Mr. Chairman, I was pleased I forgot if it was Iraq or Jordan or wherever we were, that I received the message that this bill was going to be brought up this week. And it seems to me, I was listening.
I think I gave it to you first, didn't I?
Well, I don't know if you were before or after my BlackBerry, but
Yeah.
it was very
Probably after the BlackBerry. I'm always after the BlackBerry.
But I was thinking it's a sending of letters to get things done. We wish this had been dealt with a long time ago.
Right.
But it sort of put me in mind of that story about the Methodist minister who was sick. And the head of the Board of Deacons called the board all together, and they had a long discussion about what they should do about the illness of their minister. And finally, by a vote of 4-2 with 29 abstentions, they moved to write a letter to the minister urging him to get well. And in my view, this should have happened a long time ago. I'm glad it's here now. My understanding is, and I hope Mr. Brady can confirm this, that this bill will pass first, and then that we will work on the trade agreements. I assume that's the deal that's been worked out, and I hope that's what occurs.
Well, let me just say that obviously we'll be making a determination at a later point. You do know, of course, for 5 years, as Mr. Brady has just said correctly, we have had first the Colombia agreement was signed, and then we saw the Panama agreement signed, and then the Korea agreement signed, and we're working on TA. I believe very strongly that this needs to be done together. I'm supportive of trade adjustment assistance, and the main reason I'm supportive of it is that I think it's critical for us to pass these trade agreements. And so the question of, I want them to be done together.
All three of those. And the TAA? Or are you
At
talking
the end of the
TAA
day,
alone?
at the end of the day, I hope that we'll be able to put everything together. There's still some discussions taking place right now, and we're going to make a determination from here as to what order they're considered in. But I'm convinced that in a bipartisan way, we can come together and get all of them done. So I don't have any questions other than to express appreciation to both of you for your strong commitment and your work on this issue. Mrs. Slaughter really laid it out beautifully for us by talking about the need to move proposals that do enjoy bipartisan support, the areas of agreement to create jobs, and this is one of it, and seeing the two of you at the table is evidence of that. So I have no questions other than to thank you. Mr. Sessions.
Mr. Chairman, thank you very much. I join by welcoming both of you, not only to the Rules Committee with great news, but a chance for both of you to appear together on an opportunity where we can say to the American public we're working together on an issue that we both sides agree with, but that is also about strengthening our relationship with our friends and trading partners around the world. And I think that this will be a great step. I appreciate the White House. Did I say that? I appreciate the White House, engaging this with
We hope
us.
that there's some people from the Fourth Estate in the room to hear Mr. Sessions say
Yeah,
that.
so-
Do you want to say it again?
I believe that the White House has brought us a bill that we can make happen, and I encourage our friends in the United States Senate to do the same also.
Thank you very much. Mr. Hastings? Ms. Fox?
I have no questions, thank you.
Mr. Bishop? Mr. Woodall? Mr. Nugent? Mr. Scott? Gentlemen, thank you very much for being here. We greatly appreciate your hard work on this issue, and we look forward to its consideration. I don't know exactly when it'll be, but we're going to get her done.
Great, thank you, sir.
Okay, thank you very much.
Thank you.
We are awaiting the arrival of Mr. Whitfield and Mr. Waxman and Mr. Griffith and Mr. Sullivan. So I think we might create an opportunity. It's a good idea. Our brilliant crack staff has said, why don't we report this rule out that we've just considered as we wait for the witnesses for the next hearing. So are we ready to go? Okay, the chair will be in receipt of a motion.
Mr. Chairman, I move the committee grant a rule providing for the consideration of the Senate amendment to the bill H.R. 2832 to extend the generalized system of preferences and for other purposes. The rule makes an order a motion offered by the chair of the Committee on the Ways and Means or his designee that the House concur in the Senate amendment to H.R. 2832. The rule waives all points of order against consideration of the motion. The rule provides that the Senate amendment shall be considered as read. Finally, the rule provides for 1 hour debate on the motion equally divided and controlled by the chair and ranking minority member of the Committee on Ways and Means.
You've heard the motion of the gentleman. Any discussion or amendment? If not, the vote occurs on the gentleman's motion. Those in favor will say aye. Those opposed, no. Committee chair, the ayes have it. The ayes have it. And I'm handling this rule, I guess. Okay. And Mr. McGovern will be handling there. Okay. We're still awaiting. You can vacate the chair there, Mr. Halpern, and we'll look forward to Mr. Whitfield and Mr. Waxman.
Mr. Chairman, you're the model of efficiency today.
No, I think that and the membership of this committee have demonstrated that.
Is that a picture of your Malibu property?
Why don't we proceed? Members have been waiting, and we'll recognize Mr. Whitfield as soon as he arrives. But we're happy to have our friend, my California colleague, Mr. Waxman, here, and I'm talking slowly for the first time in anticipation of Mr. Whitfield arriving. But why don't we proceed? And let me just say that, as I did to the last panel of witnesses, the reason it went so quickly is that I noticed that they, just like you, had brilliantly prepared statements before them, and I was able to gain unanimous consent from the committee to have those statements included in the record, and they were able to offer a summary. And so I'll say the same to you, and means that you don't have to go through your entire prepared statement because it'll appear in the record for the Rules Committee for everyone to see. So,
Well, thank you very much, Mr. Chairman, and members of the Rules Committee. I appreciate the willingness to make this statement part of the record in its entirety. We're going to have on the floor what I consider a frontal assault on public health and the environment. We have already noted in a report that our Democratic staff put together, 136 times this Congress has voted to block action to address climate change, to halt efforts to reduce air and water pollution, to undermine protections for public lands and coastal areas, and to weaken the protection of the environment in other ways. The two EPA bills we'll consider on the House floor are part of this concerted attack on our environment. They would gut clean air provisions that protect American families from toxic air pollution. Toxic air pollutants are those kinds of pollutants that cause cancer, birth defects, and brain damage. And the ability of our children to think and learn will be impaired because of their exposure to mercury and other dangerous air pollutants. In 1990, we adopted the Clean Air Act on an almost unanimous bipartisan basis. The law directed EPA to set standards requiring the use of maximum achievable control technology to control emissions of mercury, arsenic dioxide, PCBs, and other toxic emissions. This approach that EPA has used under the law has worked well. Industrial emissions of carcinogens and other highly toxic chemicals have been reduced by 1.7 million tons each year. EPA has reduced pollution from dozens of industrial sectors. More than 100 categories of sources have been required to cut their pollution, and this has delivered major public health benefits to the nation. But a few large source categories still have not been required to control toxic air pollution due to delays and litigation. And the bills we're discussing today would block and indefinitely delay EPA's efforts to reduce toxic emissions from two of these major sources, industrial boilers and cement plants. They would also rewrite the MACT standards to weaken the level of protection and set up new hurdles for EPA rules. We're told that these bills simply give the EPA the time they requested to get the rules right. That's nonsense. EPA vigorously opposes those bills. And we're told that we need to pass these bills because the threat of EPA regulation is dragging down our economy. I think that's legislative opportunism at its worst. So I oppose these bills on substance, but I also have concerns about the process as well. When we organized the Congress this year, the majority leader announced that the House would be following a discretionary cut-go rule. This requires first that when discretionary funding is authorized, it is explicitly limited to a specific amount. The protocols also require that the specific amount be offset by a reduction in existing authorization. This rule was embodied in a document entitled Legislative Protocols for the 112th Congress, and the majority leader, Mr. Cantor, says that compliance with these protocols is necessary for legislation to be scheduled for floor consideration. Similarly, we had another issue like this when Chairman Upton stated that the Energy and Commerce Committee would follow these discretionary cut-go rules, and he sent a letter to me in June to clarify this discretionary cut-go policy with regard to bills pending before the committee, saying, quote, if CBO determines that any of these bills will have a significant impact on the federal budget, we will offset the newly authorized spending with reductions elsewhere, unquote. Well, CBO has determined that both of these bills that will be on the floor this week do in fact authorize new discretionary spending, and CBO determined that these bills will have a significant impact on the federal budget because the bills require EPA to spend resources on proposing and finalizing new regulations. CBO estimates that implementing these bills would cost EPA $2 million over a 5-year period. Now, if the Republican leadership is abandoning its discretionary cut-go policy in order to get the Clean Air Act, I'd encourage you to simply announce that decision rather than pretending that we'll comply with discretionary cut-go. If the Republican leadership intends to comply with discretionary cut-go, then I strongly believe the committee should have the opportunity to consider what offset is appropriate to be added to the two bills before they are considered on the House floor. I understand you're talking about an open rule, modified open rule? Or
That's what we're talking about.
And
So would allow any member to offer amendments to the...
that's better than we've had in the past, and so that will be helpful. But I do want to raise the substantive issues where we have disagreement on the policy and this procedural issues, which goes to the rules that the Republicans say they're abiding by.
Well, thank you very much, Mr. Waxman. I appreciate it. And let me just say to Mr. Whitfield and to Mr. Griffith, the last panel that we had went more quickly than we anticipated, and so we appreciate your coming over. Mr. Whitfield is the distinguished chair of the Subcommittee on Energy and Power, and of course we have the author of the legislation, our colleague, Mr. Griffith. And Mr. Whitfield, please know that any prepared statement you have will appear in the record unless there's objection, and there appears to be none, so it'll appear in the record. We welcome your summary.
Well, thank you very much, Mr. Chairman and Ranking Member Slaughter and the other members of the committee. We appreciate your giving us the opportunity to be here today to talk about the rule for these two important pieces of legislation, the Boiler Act and cement rule legislation. I would just like to address the cut-go measure for one moment. As we know, EPA is being unusually aggressive on their regulations at this time, and they're doing so within their existing budget. So we genuinely do not feel that they're going to need any additional funding to reconsider their two regulations that we're talking about here today, the Boiler Act and the Cement Act. So I don't think that there's any violation, in my view, of the cut-go responsibilities. I might also say that the Boiler Act legislation is going to apply to over 200,000 boilers and incinerators nationwide. All we're asking, and I might also say that EPA itself is trying to reconsider a part of the Boiler Act regulation because I think they're concerned about some parts of it. They actually tried to get the courts to give them the time to reconsider, and the court was unwilling to do so. So our legislation basically simply directs EPA to issue final rules 15 months after the date of the enactment of this act, and to extend the compliance deadline from the 3 years that EPA is suggesting to 5 years. And we're doing that because the entities affected by this legislation have all made it very clear that it's going to take a lot longer time than they had originally thought. We also are asking that EPA in the new rules should make clear that the rule is achievable in practice and that the emission standards can be met under actual operating conditions. And then we also clarify in our legislation that the EPA administrator should impose the least burdensome regulatory alternatives. And we do that because President Obama himself, in Executive Order 13563, asked that his regulatory bodies should impose the least burden on society consistent with attaining the regulatory objectives. So in my view, we're simply asking by legislation to impose what the President has already asked for. We also In the Boiler Act regulation, without getting too technical, they changed the definition of solid waste. And what that ultimately is going to mean is that these entities that are burning solid waste or renewable solid waste to produce energy are not going to be able to do it unless they qualify with the more stringent incinerator rules. So what you're going to see is you're going to see more tires and material that is being burned now going to the landfills. So we simply, basically what we're doing here is we're codifying the definition of solid waste that President Bill Clinton issued in the year 2000 in his EPA. So I don't think that we're being unusually difficult in that regard. And on the cement, and I might say independent analysis have indicated that 230,000 jobs will be at risk with this legislation. On the Cement Regulatory Relief Act of 2011, we basically are doing the same thing here as well, just simply trying to slow EPA down. We're giving them 15 months from the date of enactment to issue the final rules. We're extending the compliance deadline from 3 to 5. We're simply saying that the emission standards set by EPA in the new rules should be achievable in practice, and that the emission standards can be met under actual operating conditions, and that the EPA administrator should also impose the least burdensome regulatory alternative consistent with President Obama's own executive order. And so I'm delighted that you are going to consider an open rule. I think that that's the process we've tried to follow to give everybody an opportunity to offer their amendments, have the debate, and move forward. So thank you very much.
Well, thank you very much, Mr. Whitfield. I appreciate that, and we're very pleased to welcome for what I think is his first appearance before the Rules Committee. And again, as I said, the other panel finished much earlier, and you were the first charge up. I just wanted to make sure that you were at the table, Mr. Griffiths, so welcome. We're very happy to have you. Congratulations on authoring this legislation, and we, as I've said to the other two witnesses, if you have a prepared statement, we'll enter it into the record without objection, and we'd welcome your summary as well.
Thank you. I will only add to Chairman Whitfield's comments that he was talking about the industrial solid waste rules, that's why we have some interesting allies on this bill, including a lot of the folks from the biomass energy area, because the unintended consequences of some of the rules put into place by the EPA that this bill would fix are in fact the biomass industry as well as the folks that you would normally think that would support such a measure.
Good. Well, thank you very much, and congratulations on the legislation. Let me just respond to Mr. Waxman's point on the Cutco issue. As I'm sure you know, that we have no plan whatsoever to waive the Cutco requirement in this rule. This is simply a protocol, and I was just informed by staff that they had read, and you know, the total cost would be $1 million over a 5-year period of time for the EPA, and there was just a report that they are going to be saving $300,000 at the Environmental Protection Agency by reducing security costs by closing 3 entrances over that period of time. That alone would more than offset this, and so we don't intend to waive the Cutco rules. So I just want to assuage any concern that you might have over that.
Well, if I could
Sure, of course.
raise the issue again with you. The Cutco rules, discretionary Cutco rules, were part of a protocol. They're not part of the rules. I guess they're not enforced as a rule. Right. But this was the statement by the Republican leadership that you would require that there be an offsetting of any of these costs. The Government Accountability Office says there is a cost when you mandate an agency do something, whatever that cost may be. Mm-hmm. You can say that they can use their own resources, but you have to have some authorization to that effect. We had this issue when we had the Train Act, mm-hmm. and we raised the same concern, and instead of doing what the Rules Committee plans to do, ignoring the problem, our committee had an offset. Mm-hmm. Now we're not going to have an offset, and it's not a rule, it's only a protocol. It's either worth doing or it's not worth doing. But it's not something you're supposed to do selectively. If you say this is important to do, do it. If you don't think it's important, then don't announce this is the way you're going to operate.
Well, we appreciate your perspective on it, Mr. Waxman.
I appreciate
Thank you.
yours, too.
Thank you very much. Mr. Sessions.
Mr. Chairman, thank you very much, Mr. Whitfield, Mr. Griffiths. Chairman Whitfield, Mr. Griffiths, I want to thank both of you, Mr. Chairman. I appreciate you taking time to be with us also. I was once again not surprised to hear some 230,000 more jobs are at risk, direct risk, as a result of what I consider to be reckless action by the EPA to kill American jobs through regulation. I think it's an interesting argument to point to all the health risks that are out there when in fact these are brand new rules and regulations which are directly designed really to have America have to buy its cement from overseas companies. It's meant to gut the industry. It is meant to diminish jobs in this country, and it once again plays directly to the point that the EPA is reckless not only in their behavior of how they have rules and regulations, but harms American business in the process. Chairman Whitfield, you were here last week as we talked about the EPA rule that has now been extended to Texas, where we will be expected to cut out 18% of the generation of electricity in Texas in January. We were just ordered to do that. That will come at a very difficult time for Texas in January. It's very cruel in terms of the amount of people who will be impacted with blackouts all across the state of Texas. And it is causing many businesses now to go get diesel engines to prepare for this, which means diesel will be thrown into the air, which I believe is not an unintended consequence, but rather a plan from the EPA to diminish jobs in America, to harm employers, and to diminish not only the stock market, but America's future to be competitive with the world. And so I appreciate you standing up today and talking forthrightly with the facts of the case. I understand what their agenda is. It's a reckless agenda that is based upon people who I believe are more tied to the demise of America than anything I've ever seen in the past. And I thank you for being here. I yield my time.
Thank you, Mr. Chairman. I believe I heard that the EPA is in the business of doing away with jobs. Isn't that not true, that these bills, which are about a decade overdue already, create jobs and create, I think a figure that I've seen was pretty astonishing of the amount of money that would be saved, but let me let that part go. I don't see the EPA as public enemy number one, but let me just say this. I want to say to Mr. Whitfield, I know we had a debate here recently on cost-benefit analysis. Now, these industrial boilers and incinerators, the largest sources of airborne mercury pollution in the United States. Mercury is a powerful neurotoxin that damages the ability of infants and children to think and learn. Industrial boilers and incinerators also emit lead, arsenic, and other toxic metals, which can cause cancer, damage to the nervous system, and other serious health effects. Have you done any cost-benefit analysis on the persons who will be hurt by this bill?
Well, we think that some of the people who will be hurt will be the children of people who lose their jobs and the impact that it will have on their health. But let me just make one other comment. EPA, even in its own analysis, did not assign any benefit at all from the Boiler Act that would be obtained by reducing mercury emissions, simply because the emission standard is already so high. Their calculation, all of the benefits of the Boiler Act from their calculation came from reduction in particulate matter, not mercury.
Well, it's mercury that is certainly have played heck with the Great Lakes and the fishing industry. We still can't eat the fish out of Lake Ontario 20 or 30 years later. I mean, I really don't understand why the health of Americans seems not to matter at all in this Congress, in this House. I think if you ask a worker who was faced, would he rather have his child be damaged mentally or to have this go into effect, that you might find a different answer than the one you just gave me. I'm not sure. Maybe they don't care, but my sense of it, that people that I've talked to really like to breathe clean air and drink clean water, and the damage that these things do, not just to the human being, but to the environment itself, and lasts, as I said, for decades, to try to get rid of. I mean, I'm absolutely baffled by this war against the EPA.
Well, I'm just saying,
But
Ms. Slaughter, that
if I may just say this, and then, I know we're going to pass it. There's no question about it. It's going to be on the floor. I would like to ask Mr. Waxman a couple of things. But the Clean Air Act of 2000 said this had to be done right away, right? And we're already a decade behind.
Well, the law was changed in 1990, and that
2 decades.
and in 2000 we were supposed to have regulated these toxic air
By n-
pollutants.
yeah.
That was 2000. This is 2011. The way the law has worked, and it's worked well when it's been applied, is that you have a compliance, and the industries have been able to comply. We haven't seen a loss of jobs in some cases. In most cases, we
You
see an
see
increase in
increase in
employment.
jobs, yeah.
But let me just point out that this bill does not require compliance with standards in 5 years. Both bills say that compliance cannot be within 5 years. There's no deadline that sources ever comply. Every other industry that has been regulated has complied in 3 to 4 years, and these bills will leave dangerous air pollution left uncontrolled indefinitely. They may want to declare war on the EPA, but it seems to me if they're talking about job-killing regulations, we ought to realize that they're children-killing pollutions that we need to regulate. And the Congress ordered it to be regulated a long time ago, and we should get on with it.
It's really very concerning to me that the health of human beings does not factor here at all. But yet we're talking about human beings with their jobs, but I can't imagine any father or mother who would say, "Well, go ahead." But the fact is that this damage lasts for decades, if not longer.
Well,
We don't know how long it's going to take to get rid of mercury in some of the lakes.
Well, EPA was unable to put a price tag on the value of birth defect or brain damage caused by mercury, but because they couldn't put a number on it, that doesn't mean we should ignore
It's certainly there,
it.
right?
It's there.
And the cut-go piece now, I found these answers a little unsatisfactory to me. I mean, this was, what's it been, 9, 10 months? No, 10 months this month. And we're waving it around already. That shows the importance of that. Mr. Waxman, is there any comments that anybody else has made here today that you would like to have some time to speak on?
I got my turn, they get
Feel the
theirs.
same way I do. All right, thank you very much. Thank you all.
Thank you, Mr. Chairman, and I want to congratulate Mr. Griffith also on his bill. And I just want to say that I didn't have a chance to look up hyperbole, but I think if there were a definition for hyperbole of hyperbole, we would have probably heard it here tonight. Some people may not call the EPA public enemy number one, but there are a lot of folks in this country who are very concerned about the role of the EPA right now and the damage it's doing to our country. So I appreciate the common sense approach that the committee has taken to some of the proposed and existing rules of the EPA. Thank you, Mr. Chairman.
I think that was a good statement saying that EPA is not, it's a hyperbole to say EPA is public enemy number one.
I would just like to make one comment to Ms. Slaughter's comment. The analysis that we've seen on mercury that's present in the U.S., that 98% of the mercury present comes from nature and air winds from other countries. So, and I would reiterate that EPA does not consider any benefit coming from reduction of mercury in this WaterMac rule.
Yeah, thank you, Mr. Chairman. I'd like to insert in the record the statement of the administration policy, which says that if presented with H.R. 2250 or H.R. 2681, that the senior advisor would recommend a veto of the bill. I just wanted that for the part of the record. Thank you. And we're talking about hyperbole here. I want to take issue with something Mr. Sessions said about those who are supporting the EPA, or those in the EPA, or those who support, I think, some reasonable regulations that somehow that we're tied to the demise of America. I think that's a little bit of an overstatement, to be quite honest with you. I think reasonable people could have a debate on some of these issues and come to different conclusions. I think people who work for the EPA are every bit as patriotic as people who are members of the Tea Party or anybody else in this country. And I think the EPA, if we look at this objectively over the years, I think it was a good thing for this country that we had an EPA to help institute and implement the Clean Water Act and the Clean Air Act. I think most objective, analysis will tell you that some of these landmark pieces of legislation actually saved people's lives, extended the lives of people. Yes, there are other countries that are emitting, pollutants into the air, and I would wish that some of our trade agreements, which everybody seems to be so excited about, would incorporate stricter environmental standards on some of those countries to follow some reasonable regulation of their own, so that they're not sending their pollution over to us. But I just, I think there's great value in the Clean Air Act. I think some of my colleagues may want it, if it was on the floor, would vote to repeal it. I think it was a good piece of legislation. I think the EPA is a good organization. Believe me, I have my problems with the EPA. I fight with them all the time in my district over some of the things that they do. But most of the challenges that I bring to the EPA are not over science. They're over the fact that there's no funds to implement any of the regulations. And we've cut back on so many of the clean water and clean air programs that we've had in this country that it makes it more difficult for communities and states to comply. Doesn't mean that, the science isn't there to say that some of these regulations are, in fact, good for the health and well-being of the people. But I just, as we debate these issues, I mean, EPA, referring to EPA as public enemy number one, or talking about people who are supportive of some of these regulations as somehow being tied to the demise of America, I think it's a little bit much. I'd like to think we could lower the rhetoric on this and, and debate the science and debate the, the cost-benefit analysis. We may come to different conclusions, but that doesn't mean that we're not all good people. So, anyway, I thank the gentleman.
Mr. Bishop. I thank presenters, and I have a question about the indefinite delay of the implementation of these regulations. How is that going to make the regulatory environment more certain for business? I'm curious about that. Would it not be that if we didn't have a delay and the rules were in place, whether business agreed with them or not, at least they would have the rules? But now by delaying it, that's going to make it more certain? Am I to understand that from our witnesses?
Are you asking me that, Mr. Hastings? Well, I would just say that from the hearings that we've had and the testimony that we've heard, the common theme has been from those entities that are trying to comply with these proposed regulations is that they simply don't believe that they can comply within the 3-year period of time. It's a lot more complicated than it may seem. And so this legislation is not radical in any way. We simply say the compliance time would go from 3 years to 5 years, and that the final rules would come out 15 months after the enactment of this act, and then we just say, adopt the least burdensome regulation pursuant to the President's...
Well, then answer me, please, whether the Boiler Act rules are currently in an administrative state.
Are they currently in the administrative state?
Mm-hmm.
Yeah, some are and some aren't. That's correct.
Okay, so then what's happening apparently is the Environmental Protection Agency is reviewing industry provided data. So in some respects, if you say some are and some are not, then we don't know the ones that are not, what the rules are going to look like. So how can you say rules are no good when you don't even know what they're going to look like?
Well, we know what some of them are going to look at. I mean, for example, we've had many universities and hospitals testify of the extraordinary cost burden that they're going to have because of the change of the definition of solid waste, for example, which means that you cannot burn certain things anymore for energy production, and they changed the definition of solid waste. They expand the Franken rule. They changed the Franken rule application, which is really a
Those are the ones that you know. I'm saying the ones where the stay is in place and the standards are being reviewed and the rules have not been promulgated. I'm asking, how do you know what those rules are going to be? And the fact is you don't. So then how can you say that they're going to be bad for industry?
Well, all I'm saying is from all of the hearings, all of the testimony from EPA regulatory representatives, the effective date of the Boiler Act rule is going to be April of next year, and we already know basically what the final rules are looking like because of the testimony that they've given.
I see. Mr. Waxman, you have any?
Well, look, the bill, first of all, takes all the rules and says we're nullifying them. And then tells EPA, you could go back and work on all these things, but you better not come up with a new standard until 15 months after the enactment of this bill. And then after they say you can't come up with a new rule, then they prohibit EPA from requiring facilities to comply with any new standard for at least 5 more years. So when they finally do come up with a rule, it cannot be required to comply, even though most industries comply within 3 or 4 years, because you can't even comply within the next 5 years. And then there's no outer limit. There's no requirement that they ever comply. A 3-year delay, if we're talking about 2018 at the earliest, 3 years later than EPA's current plan, would mean 20,000 premature deaths, 12,000 heart attacks, 123,000 asthma attacks that could have been avoided. So there are real-world consequences, and I'm not sure that we could even talk about 3 years as the outside limit to find a compliance. So it just seems to me that EPA ought to continue to work on these rules, but not be prohibited from acting, and then prohibited from requiring compliance under the usual compliance requirements.
Right. Well, let me tell you what I think is going on, and it's the majority's prerogative to bring matters of this kind. The administration has made it very clear, and my colleague, Mr. McGovern, introduced the administrative policy that basically says that if this measure were to be presented to the president, that it would be vetoed. I go a step further than the administration and say this measure isn't going to be presented to the president in the first place because the Senate isn't going to take it up. And so basically what we're doing here is attacking the Environmental Protection Agency for political purposes of the majority. And again, that's their prerogative. I tend to disagree with much of it, and I somehow find it anathema that we would be in a position, and I will speak to my colleague outside and inside again. I agree with Mr. McGovern. We shouldn't accuse not only the Environmental Protection Agency, but none of us of being about the business of the demise of America. I don't know what talking point Pete got that from, but I don't think anything that the Environmental Protection Agency is doing, I don't think anything it did for 40 years was about the demise of America. And I think what we should be doing here is both clean air standards and appropriately addressing unnecessary regulation. And somehow or another, we don't seem to be willing to do that. For my purposes, Mr. Waxman, if one person is going to die because we fail to undertake to do what is responsible, then that's too many people for me. I don't know about 20,000 premature deaths. I do believe that if the air is not made better, or that there will be health consequences, and that it will have an enormous impact on our industry. The thing that continues to surprise me, Mr. Whitfield, when we had the previous discussion, I had not read an article about the Tennessee Valley Authority and the amount of pollution that had been dumped into the areas that caused some of the closures. If you recall, I asked you whether or not there had been closures of coal-fired plants, and you went to TVA. Well, in this particular instance, what continues to puzzle me is how it is, let's use cement manufacturers, and we have a whole lot of it in Florida. How is it that certain members of the industry conclude that I can meet these standards? As a matter of fact, I can even do better than that and meet them, and then we pass legislation that will maybe help 100 of these businesses, and somehow or another that's supposed to produce jobs. You people need to get it straight. You're in the majority, but you may wind up in the minority if you continue that way. Thank you.
Thank you, Mr. Chairman. And I'd like to thank my freshman colleague for bringing this bill. It's another, maybe your first trip to the Rules Committee, but it's another in a long string of contributions that freshmen are making right off the bat. And I was concerned about something my colleague from Florida said earlier. It said kind of cynically that this was just something that folks could do for political purposes. What part of the country are you from, Mr. Griffith?
I come from Southwest Virginia, which has lots of jobs on the line.
I just wanted to find out, because I know you're home doing town hall meetings just like I am. You're home out with folks every day just like I am. You're out talking to folks whose homes are getting foreclosed on just like I am. Have you talked to anyone in your part of the world who believes that you've brought this bill forward for political purposes, or do they actually think you're trying to make a positive difference in their life?
No, they believe that this is a positive bill that I put forward on their behalf.
I believe that too. I believe that too. I'd be happy to yield to my friend.
I wasn't talking about the presenting of this particular measure. I was talking overall. The planned attack on the Environmental Protection Agency, I believe, is a political ploy, not what Mr. Griffiths has brought here. And I did and do take umbrage. Pete is back here now with saying what the Environmental Protection Agency is doing is about the business of causing the demise of this country. I know Mr. Griffiths is particularly serious about the measure that he brought. You may be surprised, and he may be surprised. When it comes to the Boiler Act provision, I've written my own letter to EPA regarding same. So I dare not attack a colleague for bringing it, but I will attack the majority for the political undertaking that's going on with reference to the Environmental Protection Agency, and I'll believe that until after the election.
Gentleman yield.
I'm grateful to my friend for clarifying, because I too believe, I share his belief that this is a thoughtful measure that has been brought forth because of challenges that real people are facing every day, and that balance that we have to come in. I'd be happy to yield to my friend.
I would hope, and I am not going to say that anybody has miscast my words, the demise of America and America's jobs is what my statement is, demise America's jobs. I think that's very apparent to me, and I have stated that. And if you lose American jobs, one could say then the demise of America. Okay. Thank you, gentlemen.
You're very welcome. And my misunderstanding of my friend from Florida raises an interesting point. Mr. Waxman, you were talking about this discussion of jobs and regulation as smacking of, what did you say? Legislative opportunism at its worst. But I wasn't here in 1990 when they passed the Clean Air Act nor the subsequent amendments. Is there a portion of the Clean Air Act that has that mandate that the EPA focus on maximizing American jobs during its deliberations?
There is a requirement that before EPA can issue a regulation, they do a cost-benefit analysis to be sure that the benefits from the regulation are surpass the cost to them. And that's just their analysis. But in reality, oftentimes the costs turn out to be exaggerated, and the benefits are real benefits, but sometimes they're hard to quantify, like a premature death, a child with brain damage. You can't always put a number on something like that. But the industry comes in and says it will cost X number of dollars, That's their claim, but oftentimes it turns out in reality to be a lot less. Plus, they become much more efficient when they do some of these pollution control efforts and become more competitive. We would hope. If regulations are smart, that's the kind of result we want.
It's difficult here, 9 months in, almost in the 10th month on the job, because I do feel like we're called on regularly to make those decisions about whether a parent's going to be able to take care of their child's asthma or be able to feed that child, because those things are sometimes in conflict as we face these economic challenges. I think Mr. Whitfield referenced 230,000 jobs on the line with Boiler Mac. My expectation is we staff the EPA not with folks who are public enemy number one, but with folks who want to protect the environment first. I suspect we staff the Department of Commerce with folks who want to grow jobs first. But my concern is, because I'm a believer in the process, I'm a believer in the House. Here we have a bill that everyone agrees is a thoughtful piece of legislation that is motivated by the care of one's constituencies. We have the chairman who's promoting a modified open rule so that all members can make any amendments that they'd like to make necessary. This seems like exactly the kind of debate we're supposed to be having here. Political opportunism at its worst sounds like a debate we shouldn't be having. I'm reading from the report. Direct the EPA to develop new rules, to adopt definitions, to allow sources to continue to use alternative fuels for energy recovery. That wasn't allowed in the original rule. I support that. That seems like something we ought to be able to find common ground on here. I'm reading EPA requested 15 additional months to repropose 3 or 4 rules. The courts denied it, and EPA only had 30 days. And on the same day EPA announced its final rules, it took the unusual step of announcing plans to reconsider aspects of those rules. Well, I don't think there's anybody in this room who'd say that's not the right way to pass legislation. That's not the right way to propose rulemaking. Mr. Griffith's given us an opportunity to sort that out. Now, perhaps this isn't the right way to sort it out, and perhaps there are going to be amendments offered to do that. But I say to the gentleman sincerely, here we have an open process on a thoughtful bill. Why isn't this legislating at its best, as opposed to your characterization of political opportunism at its worst?
My characterization is not just to this bill. My characterization was to the whole record we've had of this Congress voting to undermine environmental protections. But on this specific issue, if we sat down and talked about it, I think we'd find a lot of agreement. And I went to the Republican leaders on our committee and I said, let's talk about it. Let's see if we can work something out. And the response back was, well, we've got the votes. We're going to move it. Now that's the right of the majority to do. But let me point out that there are problems with this approach. I think it overreaches. Had we made some changes on the Boiler Mac rule that clarified some of the things that are clarified in this bill and didn't go further to say the EPA couldn't act with this time frame and nobody had to do anything with that time frame, I think we could have worked something out and solved the problem. But I think that what we've seen is a pattern. Last week we saw a lot of it. This week we're seeing more of it, of saying EPA is a job killer. We've got to punish EPA. They're public enemy number one. And that is hyperbole to me. If we wanted to work on a bipartisan basis, which we used to do more of, I think a lot of these problems that are real practical problems could be addressed. Maybe at some point we'll still get around to it on this bill.
Well, I appreciate the gentleman's comments, and one of the reasons I sought out this spot on the Rules Committee is for that very reason, that we have an opportunity. Some administrations, some speakers in the past, both Republicans and Democrats, have used the Rules Committee to shut the process down, and this speaker is using the Rules Committee to open that process up. And I hope by having that open process, we'll be able to find some of that bipartisan agreement and make Mr. Griffith's very good bill even better. And I thank you all. Thank you, Mr. Chairman.
Scott, question? Gentlemen, thank you very much for being here. Appreciate it. Look forward to congratulations on your maiden voyage to the Rules Committee. Yeah, all right. For consideration of these two measures. And as I'd said, I think think everyone recognizes. I'm hoping very much that the committee will report out a rule that will allow every member to have an opportunity to offer a germane amendment. Would simply have the pre-printing requirement so that members know what's going to be considered on the floor. So the chair will be in receipt of a motion.
Mr. Chairman, I move the committee grant H.R. 2681, the Cement Sector Regulatory Relief Act of 2011, a modified open rule. The rule provides 1 hour of general debate on H.R. 2681, equally divided and controlled by the chair and ranking minority member on the Committee on Energy and Commerce. The rule waives all points of order against consideration of H.R. 2681. The rule makes an order of the amendment in the nature of a substitute to H.R. 2681 recommended by the Committee on Energy and Commerce, now printed in the bill as original text for the purpose of the amendment, and provides that it shall be considered as read. The rule waives all points of order against consideration of the committee amendment in the nature of a substitute to H.R. 2681. The rule makes an order only those amendments to H.R. 2681 that are submitted for printing in the congressional record not later than the legislative day of Tuesday, October 4, or pro forma amendments for the purpose of debate. Each such amendment may be offered only by the member who has caused it to be printed or designee, and each amendment shall be considered as read if printed. The rule provides one motion we commit H.R. 2681 with or without instructions. The resolution also provides for consideration of H.R. 2250, the EPA Regulatory Relief Act of 2011, under a modified open rule. The rule provides 1 hour of general debate on H.R. 2250, equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule waives all points of order against consideration of H.R. 2250. The rule makes an order of the amendment in the nature of a substitute to H.R. 2250 recommended by the Committee on Energy and Commerce, now printed in the bill as the original text for the purpose of the amendment, provides that it shall be considered as read. The rule waives all points of order against consideration of the committee amendment in the nature of a substitute to H.R. 2250. The rule makes an order only those amendments to H.R. 2250 that are submitted for printing in the congressional record not later than the legislative day, Tuesday, October 4, 2011, or pro forma amendments for the purpose of debate. Each such amendment may be offered only by the member who caused it to be printed or designate, and each amendment shall be considered as read if printed. Finally, the rule provides one motion to recommit H.R. 2250 with or without instructions.
You've heard the motion, gentlemen. Any discussion or amendment?
Yes.
Mr. McGovern.
Mr. Chairman, I have an amendment to the rule. I move the committee grant H.R. 2250 and H.R. 2681 each an open rule so that all members have the opportunity to offer amendments to the bills on the floor. Mr. Chairman, this is not an open rule. Under this rule, a good idea that is not ready by the arbitrary deadline in this rule for any reason cannot be offered. My amendment simply allows that when this bill comes up, it comes up under a truly open process.
Thank the gentleman. Let me say the gentleman is absolutely right. This is not an open rule. Let me say it again. This is not an open rule. It simply says that if members have ideas, they should offer them for the congressional record by tomorrow evening, and I think that that's fair in this case. It's a very complex measure, and I hope that my colleagues would defeat the McGovern amendment. Those in favor will say aye. Those opposed, no. Pin the chair, the noes have it. The clerk, call the roll.
Mr. Sessions? No. Mr. Sessions, no. Mrs. Fox? No. Ms. Fox, no. Mr. Bishop? Mr. Bishop, no. Mr. Woodall? Mr. Woodall, no. Mr. Nugent? Mr. Nugent, no. Mr. Scott? Mr. Scott, no. Mr. Webster? Mr. Webster, no. Ms. Slaughter? Mr. McGovern?
Yes.
Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No. Clerk, report the total.
2 yeas, 8 nays.
The motion is not agreed to. Are there further amendments? If not, the vote occurs on the motion of the gentleman from Dallas. Those in favor will say aye. Those opposed, no.
No.
The ayes have it. The ayes have it.
Roll call.
Clerk, call the roll.
Mr. Sessions?
Aye.
Mr. Sessions, aye. Ms. Fox? Aye. Ms. Fox, aye. Mr. Bishop? Mr. Bishop, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Nugent? Mr. Nugent, aye. Mr. Scott? Mr. Scott, aye. Mr. Webster? Mr. Webster, aye. Ms. Slaughter? Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings?
No.
Mr. Hastings, no. Mr. Polis? Mr. Chairman?
Aye. The clerk report the total.
8 yeas, 2 nays.
And the motion is agreed to, and Mr. Nugent will be handling this rule for the majority,
Mr. Hastings.
and Mr. Hastings for the minority. Thank you all very much, and the committee stands adjourned.